Let's fill out a Nebraska Prenuptial Agreement together and check off every legal requirement as we go. This is Nebraska's Prenuptial Agreement, the contract a couple signs before marrying to set their own financial rules. On the right is everything Nebraska asks of it. These rules live in one act, and the statute gives that act its short name. This is a contract between two people planning to marry, made ahead of the marriage and effective when it happens. Property here means anything either person has an interest in, now or later, real or personal. The agreement has to be in writing, and that is the document in front of you. The act does not reach every agreement ever signed in the state. The statute names the date it starts from. Start with the effective date, the day the couple plans to sign before their wedding. Type the month, day, and year here. Signing does not switch it on, it takes effect when the marriage happens. If the marriage turns out to be void, the agreement holds only as far as needed to avoid an unfair result. The clock on any claim under the agreement is paused while the couple stays married. Next, enter each prospective spouse's name and mailing address, exactly as they will appear on the signed pages. The agreement calls them Prospective Spouse 1 and Prospective Spouse 2, names carried through the signature block and the schedules ahead. Each person has to sign it of their own free will. An agreement someone did not sign voluntarily does not hold against them. Further down, a clause names which state's law governs the agreement and which state's courts would hear a dispute. This is a Nebraska agreement, so both blanks say Nebraska. The couple can pick which law governs the agreement. The attached schedule lists each person's finances. Spouse 1's copy shows a bank account, a car, and some jewelry as examples. It can set each person's rights in any property, no matter when they got it. It can cover the right to buy, sell, use, and manage property. It can set how property is divided on separation, divorce, or death. State law sets how each person discloses what they own and owe, and what happens to the agreement if they do not. That disclosure can be waived only if the person does it voluntarily and expressly, in writing. Spouse 2's copy follows the identical layout, with a different sample balance, vehicle, and valuable item. It can change or drop spousal support. It can require a will or a trust to carry out what the couple agreed. It can say who owns a life insurance policy and who gets the death benefit. Anything else can go in too, as long as it does not break public policy or a criminal law. A support waiver cannot push someone onto public assistance. A court can order support to the extent needed to avoid that. The agreement closes with a signature line and a dated line for each spouse. Both people have to sign it, so neither page stands alone. Nothing in here shortchanges a child's right to support. The court decides whether the agreement is unconscionable, and it decides it as a question of law. Either side still has the usual fairness defenses, like waiting too long to enforce. Fill out your own prenuptial agreement free at FormsPal, no sign-up required.